let's start talking about the just general concepts of the psychology of jury decision making. So most of the concepts that I'm going to be talking about come from cognitive psychology, some from social psychology, and a lot of them have to do with cognitive biases. You've probably heard in theory about a number of these that I'm going to be talking about. So the first one is confirmation bias. This is you're right, I'm wrong. This is something that we see a lot of, particularly in the last couple of years. We seek out information that fits with our core beliefs, right? And we pay more attention to things that we already agree with to begin with. This is like, think about your Facebook feed, right? It's all people that you like with political views that you share. And we tend to believe that information more. And it really goes to sort of how divided the country is right now and how sometimes you think, how can this person possibly think this? It's because every piece of information they seek out fits with whatever their core beliefs already are. Now, why is this important for jury selection? It's because you are not going to change people's core beliefs in jury selection. I know sometimes people say, well, once they hear the case or once they hear the evidence. The problem with that is that they're going to hear that evidence through their own confirmation bias, through that lens that they already have. So we'll talk about this throughout the whole day, but we do not believe in trying to educate in jury selection. We're not trying to win hearts and change minds in jury selection. We are trying to find the people who are not going to listen to our story, who are going to see our case through this filter that's going to cause problems for us. All right. So the fundamental attribution error, this one you see a lot. This is sort of there's two attribution errors, fundamental attribution error and defensive attribution. Both are really important concepts to think about when you're framing your cases, and when you're thinking about who your jurors are going to be. So fundamental attribution error is that we believe that when negative things happen to us, it's because of situational factors beyond our control. When negative things happen to someone else, it's because of something that they did. So we assign a personal attribution to the negative outcomes of others, but when it's us, we tend to think that it's a situational factor and not something that we did. So this goes into the blaming of the victim that we see, the blaming of the plaintiffs, all of the reasons why this happened to the plaintiff, and then of course why it wouldn't happen to you, moves into what defensive attribution is, right? So defensive attribution, you can think of this, a million different, every single case that we have has some form of defensive attribution because it's a negative outcome, usually, or otherwise we're not at trial, and the person wants to figure out, hey, this in my mind, psychologically, how could this not have happened to me? So in an employment case, for example, they'll say, well, I would have complained earlier, I would have gone to HR. Even in a rear-end case where you would think, hey, there's no blame here. We'll hear jurors say, well, I'm always looking in my rearview mirror, and I would have moved to the right, or I would have moved to the left. So it's the searching for reasons to feel that this wouldn't happen to you. We see it a lot in cases involving children. Parents, in particular, do not want to believe bad outcomes could ever befall their children, so you always see parent blaming in those situations. Well, if I was a parent, I would have known that this was going on, or I would have vetted this more properly. So this is something that you always want to be on the lookout for.
It's kind of important also. You're going to have jurors with this type of mentality in the box. And so this will also be important as we talk about case framing and how you actually deal with comparative fault issues and get the defensive attribution out of their minds if you're stuck with them, and still be able to get a good outcome on your cases.
Absolutely, because you're never going to be able to get rid of all of them, but there are ways, and that's what we're going to do in that last section as well, is Rahul's going to talk about dealing with comparative fault and how we frame the case he's done some amazing cases where he's come out with a 0% comparative on, like, for example, the driver who hit the person gets a 0, and the school district gets 100%. And he'll talk about those cases later on today, and it really is incorporating a lot of these concepts into your case story. So there's another, I just love this meme, so right? This is again, blaming other people for what happens to you. Defensive attribution, right? I love that kid's face. All right, so these all kind of fall together. There's this idea of similar, hey, I want a juror who's like my client, right? They're gonna understand my client. They're gonna have empathy for my client. They're gonna see things through their perspective. Maybe, but maybe not. You know, if they're having defensive attribution, they're going to think about why this wouldn't have happened to them. And the problem with having a juror who's in a similar circumstance to your plaintiff is that that juror is going to be the expert in the jury room. You know, well, I was in HR, I went to HR, X, Y, and Z, or I am in a lot of pain. You know, I had a back injury and I still go and do my job every day, so I don't understand why this person needs X, Y, and Z money. We hear that all the time. So there's something in psychology known as the black sheep effect. And that is, it kind of all filters in together, right? It's also part of that defensive attribution. So it's where you want to, as part of the in-group, if there's an out-group member that's a negative connotation or something that you don't want to be associated with, you're a harsher judge of that individual than you would be otherwise, right? So that's why you have to be very, very careful with somebody who's in a similar situation as your plaintiff. 9 times out of 10, I don't like to take the risk with them. Now, what is helpful sometimes is someone who lives with someone who's similar to your plaintiff, someone who is a caregiver for someone who has similar injuries to your plaintiff. Typically, they are going to be the more empathetic, and they're going to be the more sort of objective and more on your side, as opposed to someone who is going through the same thing that your plaintiff is.
Yeah, when Sonia and I first started working together, we always do jury questionnaires whenever we have a chance, and the judge allows it and the defense stipulates to it. And I'd always get a questionnaire. I get so excited. Oh my gosh, this person's spouse suffered a back injury in a car crash. They're gonna love my client. And Sonia's like,
maybe.
Maybe, but probably not. And then I start asking that prospective juror questions and say, hey, so I understand your spouse was involved in a collision and suffered injuries. How's she doing? She's not doing well. And she's got chronic pain. And so tell me about that a little bit more. Well, we just filed an insurance claim and got our medical bills paid for, and we think that's all that, you know, she should be entitled to, and she's got to live with the pain, and it's hard for me to believe that you come in here and say that millions and millions of dollars in pain and suffering should be entitled to your client when my wife didn't get that. Like, oh, well, that doesn't feel like somebody who's going to be really favorable in my case.
Yeah, and this was a juror, we literally had this, we have this every single time, but this happened to us just last week, where this juror was otherwise pretty good on paper. We had a lot of people who were very bad on paper, so we were kind of not focusing on this gentleman, and we kind of go to him with a question about sort of non-economic damages, although we never call them that because jurors don't know what that means. But we went to them with, you know, questions about awarding money for pain, and we did a mini opening so they knew that we were seeking over $10 million for this guy. And that's exactly what he said. He started talking and he was like, I'm not going to give any money for pain and suffering because I think that's just something, you know, it's like the cross you bear if you've been injured. So again, we wouldn't have known. And this kind of also is something we'll talk about over and over again, is you cannot make assumptions about whether or not someone is good for you. It's really important to try and talk to every juror. I know in some jurisdictions you have time constraints. Federal court, you may not get to talk to any of the jurors, but there is a sizable body of literature out there. It's written by, the judge's name is escaping me, but if you email me, I'll send you it's Judge Mize. Judge Mize is a federal court judge who used to do the typical federal court voir dire, which he was like, anybody have the yes answer? Nobody? Okay, go on, you know, didn't really talk to anyone. Then he did an experiment where he took each of the jurors back into chambers and just talked to them for a minute or two. And the things that he found out that were challenges for cause were mind-blowing. You know, people who actually knew the defendant or who had treated with the same doctor, things that I think it was something like 60 to 70% of the jurors he talked to, he would have excused for a challenge for cause, and they didn't raise their hand. And sometimes it's because jurors, it's you know, people hate to speak in public, and it's a novel situation. They may not think it applies. How many times have we had it where the jury gets sworn, and they're like, oh, wait, what do you mean? I'm on the jury, I can't do this, I have this, this, or that, because they don't think that it's really happening to them as it's happening, and so they don't necessarily think to tell you some of the things that you need to hear. So it's critically important that you try your best to talk to every juror. So again, sometimes similarity equals liking, but often it doesn't. So hindsight bias, what's hindsight bias? Hindsight bias is, again, Monday morning quarterbacking. So after you know the outcome of an event, it seems easy to have avoided that event, right? And so how do we get around this in terms of plaintiff blaming? Again, it goes back to case framing, because the people who have the most, who are perceived as having the most knowledge and the most control are the ones who fall most victim to hindsight bias. So you want to talk about all of the information that the defendant had, the choices the defendant made, and not focus on your client, because then the hindsight bias can work to your advantage, because it seems so clear, well, the doctor should have known that if he did X, Y, and Z, that it was going to cause my client to bleed out. So it's shifting your focus to compensate for this tendency to say, you know, it's the I knew it all along effect is essentially what hindsight bias is.
Yeah, so there's this trial strategist up in Northern California, Rodney Jew. I don't know if anybody's heard of him, but I've had the opportunity to do a number of sessions with him. And he basically holds you in, it's not false imprisonment because I voluntarily went, but for 4 days of just sitting there and going through your case with other lawyers, and it's like 5 of you, and you just talk about all these issues in the case. And another way of looking at hindsight bias, he calls it the purple box. And if you think about a car crash or a slip and fall case, and you say, okay, at this intersection, you know, you're talking about a matter of split seconds that led to that injury-causing event. And if you want to dissect the woulda, shoulda, couldas in that split second, you're inviting hindsight bias and you're inviting a comparative fault case. And so what he talks about and taught me about was back-chaining, system failures. Where's that root cause analysis? And that takes you out of that purple box of that split second and all the missed opportunities that led to that. And like Sonia said, puts the control on the defendants as opposed to looking at that 0.1 seconds that maybe I should have taken another sip of coffee at the Starbucks and I wouldn't have even been in that situation, and all the irrational arguments that come in that expose you and your client to comparative fault and a suppressed verdict as a result of that as well.
Yeah, and what he's talking about also goes to counterfactuals. So those are the if-only statements. If only this, if only this, if only I would have stayed, if only he had not, you know, turned left or turned right, or if only he wasn't running late, he probably wouldn't have, you know, done X, Y, or Z. But you can flip those too, and you can put them on the defendant. If only they had bought the $3 widget, that would have prevented the product from failing. If only they had followed their own policy that says X, Y, and Z. So you can take those counterfactuals again and apply them to the choices and the conduct of the defendant. So the story model is, you know, the story model is incredibly important to how people make decisions. That's how we learn. I think your trial story should always be a story. I know there are a lot of different approaches to starting an opening or starting your case. We were just having this discussion last night. I know a lot of people like the rules of the road. I don't like to start with the rules of the road because it's not a story. And I think the jurors don't have the context for the rule. And I think sometimes it just plays silly. You know, like the rule is that you have to be attentive when you drive. Really? You know, I think that it can come across as a little bit condescending if you start with that and they don't have a context for it. The jurors want to know what happened and why are we here. And so, and what we know is the first story that's adopted, that's how the rest of the information is going to be interpreted. And so as plaintiffs, we have the benefit of telling the story first. And then you get into the violation of the rules. And then you get into what they did wrong. Well, actually, you're starting with what they did wrong. And we're going to talk about that in a minute. We never start with our plaintiff. And we'll talk about that. That goes back to all of these concepts we're just talking about. Because we don't want the blame and the focus to be on our plaintiff. We want it to be on the defendant. But structurally, I always like to tell a story from a point of view where the jurors are like, something bad is going to happen. Something bad is going to happen. It's building, it's building, it's building. You sort of talk about all of these failures that are leading up, and then you talk about, and this is what happened, and it happened to be my plaintiff that this happened to. And only after you've sort of, number one, got them figured out that somebody did something wrong and it wasn't your guy or your gal, then you can have the credibility to introduce the damages and the harms that have happened to your person, as opposed to starting with those.
So it's when Sonia and I were talking yesterday, it kind of started as an argument before we actually realized we were probably saying the same thing. But rules of the road and just saying, in that term of just saying, you know, here's the rule and you need to follow it, I think that is condescending and can be patronizing if you're telling a jury that. However, that rule came from some origin that hopefully makes sense. Right? And so I always try to analyze each of the rules and act like that my 4-year-old self in the back of the car as we were on a long road trip and where I'd ask my parents, why? Why? Why is the sky blue? Why is this? Why? But why? Why? And as you start kind of getting down deep into it, you're able to break down all of these rules into concepts which make sense to everybody. I call them irrefutable truths, right? And or universal truths, where no matter where you are, no matter who you're talking to, they're going to agree with you on that. And as you start teaching something, whether it's on a premises liability case, most of the jurors had no operational experience in running a grocery store or a Costco or whatever amusement park or a construction accident. Most jurors, or almost all of them, have no experience on a construction site or running it. You start teaching all of those rules, but those rules are all safety measures. And if you follow all of these, then you start to get a little bit more case specific, that's where the jury starts going, okay, I understand how, I'm an expert now in how to run a construction site. And then when you start getting into the case facts, that's what Sonia was saying. Before I even get to the conclusion of what happened, hopefully, if we do it right, the jury's already reached the conclusion before the words came out of my mouth. Oh man, defendants really screwed up on this one. Oh, why would they do that? How could they do that? What were they thinking before we're even actually telling them? And then they realize the catastrophe or tragedy that happens, and hopefully that carries through the rest of the case and through the verdict.
So typically how we like to do our structure is we do the story of the bad acts of the defendant first, then the damages of what happened to your client. But then there's one other element that we think is important to address in your openings, and that is to talk about what the defense contentions are going to be. And that is more of a point-counterpoint. A legal expository is what they call that model. So we combine that by, after we've told our story and they've adopted our story and they are going with our story, then we say, now the defense is going to try and say this, and here's why that's just silly and wrong, right? So at the end, and we like to do it at the end because it's right before they have to get up and tell that story. So we go through and sort of say, you know, they're going to say that, you know, he was late to work. Well, that wasn't true because they think he started at 9, but he really started at 9:30 that day. Or they're going to say that he had this pre-existing condition that, you know, blah, 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 but we've got every doctor in the case is going to say that had nothing to do with it. So whatever it is, we do those sort of defense contentions, which definitely steals the thunder, right? You never want to have them, you know, bad facts be introduced for the first time by the other side. You want to introduce them and diffuse them, and again, right before they have to get up and tell that story.
And hopefully, again, as you carry through, when you get to the defense contentions, just like when you actually start to get to the case-specific facts in opening, the jury's with you, and they already have reached the conclusion because you've made them experts. Once you get to the defense contentions, I'd say about 75% of the time, the jurors are already looking, going, come on, come on, you can't make that argument. And so it really creates an uncomfortable environment for when that defense lawyer has to get up and actually make
those arguments,
yeah.
right?
Yeah.
Yeah, it's good. All right, so I have just sort of an example. I don't remember what my next slide is, sorry.
This is so interesting.
This one's really interesting. So this is a psychological study, which I'm not going to get into too much of the details with it, but these are the same thing, right? They're the same thing. It's 99% fat-free or 1% fat. Which one do people buy more? The 99% fat-free, right? Because that's something that it's sort of like 1% fat sounds, I don't want anything with fat. So it's the one that has fat-free that people buy more. They've done all kinds of cool studies on this. And this just goes, I like this one in terms of if you do medical negligence cases, when you talk about risk of success versus risk of the procedure. Risk of side effects versus risk of the procedure. I also like it in pharmaceutical cases where you sort of frame the benefits of a drug. So there's all kinds of cool ways that you can apply this attribute framing. It's just something to remember, right? It's just, that's how the mind works, which is crazy. This is another attribute frame. We've all heard that we don't say accident, we say collision, right? So this was actually based on research where jurors were asked, they watched a video and then were asked questions about the video. And they were either asked how fast were the cars going when they contacted, hit, bumped, collided, or smashed with each other, okay? And the results show that, of course, the smashed 41 miles per hour. We think it's weird that bumped is in the middle, but that's the one that doesn't really fit to me. But,
yeah.
But contacted is like, that doesn't convey any sort of action, right? As opposed to smash. So that's why it's a smash or a collision, a crash, and not a accident. An accident in particular, because accident is a buzzword that we see a lot in jury selection. There's a lot of jurors out there who think that unless there was intentional conduct, you should not be suing. And so you wouldn't think that we have to address that, but you can listen to jurors' words, and that's so important, which we're going to talk about in the next section. Actively listening, there's certain buzzwords jurors say, and they say things like accidents happen. I mean, accidents happen. And then you say, okay, now, nobody's saying that Mr. Ravipudi intended to hit, Miss Jones. Do you feel like, if he didn't intend to hit her and didn't intend to hurt her, then we shouldn't be here? And some jurors will say, yeah, that's just an accident. That's just, and I think a lot of times people attribute just an accident with, so that should just be an insurance issue. We should only be here at trial for things where people have actively done something. Right? So you need to address this intentionality aspect of negligence. So this is my example of the fundamental lawyer attribution error, right? This is how so many lawyers start. You say, okay, welcome, ladies and gentlemen. Let me tell you about my client, George Hernandez. He was 68 years old at the time of the injury. He grew up in California. He's got a lovely wife who he's been married to for 1 million years, and they have these children who love them, and they have all these grandchildren, and they've been married for 40 years. They met when they're in high school. They dated for 3 years beforehand, and they got married. Here's the grandkids. We've got Robert, who's 12, and Tom. So here's the point. I see a lot of people start their cases like that. The jurors don't know who these people are. They don't care. They come in suspicious of you and think that you're only trying to get sympathy for them, and they don't know why you're telling them this. This has nothing to do with what happened. I want to know what happened. So this is a mistake to start with your client. Now, you can introduce your client, and there are reasons why you want to introduce your client that we're going to talk about later in terms of making sure that the jury sees them, but do not start your case with your client, because number one, I don't care yet. I'm not invested in it. I think you're being manipulative. I think you're trying to play to sympathy, and that is the number one thing that jurors hate the most, is feeling like they're being manipulated. Number one thing from either side. So we want to always try to avoid doing anything that's going to lead them to feel that.
Just keep in mind, if you think about the timing of things, you've just finished jury selection, and during that whole time, at least the way that we do it, we're trying to identify all the negative jurors, all the things they already hate about the concepts in our case, and all that negativity, just to see if we can get some fair and impartial jurors. And then the next thing you do is you turn on a dime and just start playing the sympathy card. First shot, first thing out, you haven't earned their respect yet. And so that's why kind of working through really almost a verdict form. You start with responsibility and then move into damages on the second part. that's how you actually earn the credibility of that jury.
And again, you know, and Rahul will talk more about this later, but this is particularly true where your focus is where you want their focus to be, particularly true in a comparative case, for example. We had a case, I don't know if you remember this one, I don't remember the name of it, but it was a guy who was on a motorcycle and he gets hit because a load falls off a truck. But we're really going after the state. The whole reason the load fell off the truck, in part, was because of the road. So it's actually a case where we're going after the conditions of this roadway. The easy answer is, well, the guy loaded the truck wrong, and hey, probably your guy's on a motorcycle, so he's probably doing something wrong too anyway, even though they weren't saying that. And so originally the opening started with, so, you know, Joe loads up the truck at 7 o'clock that morning and, you know, he misses a latch, and then our guy comes along and he gets tipped over because of this. And when we first started thinking about it, I think we did a focus group in it, and we said, no, this is the story of the road. I want them focused on the road. So instead we go back to when the road was designed. And when it was designed for much less traffic than it currently had. And it goes back to the maintenance that has lapsed over X, Y, and Z years. And the guy who was supposed to come out and trim the bushes, but didn't trim the bushes. So we start our entire focus where we want that focus to be, which is on whoever your primary defendant is. And he's got a million examples of this that I think you'll be talking about a little bit later on today. All right, so instead, here's the example where I'm not starting with, you know, Mr. Hernandez. I'm starting with the president of the company. I'm starting with, you know, in this case, here's the driver. And in this case, it was fine because he was employed, he was on the job. So it's okay if they hate the driver in this case because I wasn't trying to get it on another defendant. So we're talking about the bad acts of this corporation and these corporate officers. That's where we're starting, not with the client. All right. So now I want to move into a couple of other psychological concepts that have to do with damages. And some of you will have heard of some of these. And there are some, again, I'm a science geek, a literature geek, so if anybody wants the actual articles and wants to learn more about how the studies were done, email me and I will be happy to send you these. But I'm just going to go over them sort of broad strokes. So how many of you have heard of anchoring with damages? Probably a lot of you have heard that, right? And anchoring is a concept that actually started, interestingly enough, with a roulette wheel. They, the study was totally random. They would spin a roulette wheel, and then that would be a number. And then later, they would ask participants how many countries are in Africa. And it centered, because nobody knows that apparently off the top of their head, and whatever number they rolled in the roulette wheel determined that it anchored what their response was of two totally random things, right? And so we have to, as trial lawyers, you need to be aware of what anchors are going to be in your case. We see this a lot sometimes when you have, and we had another discussion about this last night. Yeah. What do you do with a low economic damages case? Half the people in the firm say, dump them. I don't want to anchor, the $50,000 wage loss. Rahul feels differently.
I'm Indian. I'm cheap.
Yeah, right. We're both Indian. We're like, we're not going to leave $50,000 on the table, man. So you got to think about, and if you want to have those included, then you have to talk about that, and you have to think of other ways to anchor the jurors away from the non-economic damages. But you have to keep in mind that there is going to be an anchor. This is why it is so important to give a number. This, among other things, is why it's so important to give a number. A lot of times I know people are reluctant to say how much you think that they should give for emotional distress and pain and suffering. Absolutely have to do it. They have no idea. We've done a couple focus groups where in one room we'll tell them and one we don't, and they come back with like $100,000 in a case where the ask was probably going to be $5 or $6 million. They just don't know. And so you have to provide an anchor for them. A good defense will also provide an anchor, but not all of them do because they don't like to talk about money at all. That's typically, it goes both ways. I mean, we have seen mock jurors say, well, why are they even giving us a number if they didn't do anything wrong? But I've also seen if they don't give an anchor at all, then of course they're only adjusting around the plaintiff's number. So the other thing that we sometimes see is, focus groups are not predictive of damages, but what